Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. Fantastic. Looks like I was on video there for a second. Maybe that'll be on the YouTube stream. All right. Anyway, we're rolling today. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. Today, I was so excited about the show. I posted, we're going to go live in 55. I thought it was Tuesday, or I thought it was Thursday morning, and I was about ready to launch this thing on 10 a.m. Pacific instead. Okay, there's three hosts to this show. My name's Todd Ryan. Jeff Neuman and David Michaels are my co-hosts. I like to say hi to them before we get rolling through this jam-packed show full of info. Hi, Jeff. How's everything going with you?
Hey, I am exhausted. This week, ICANN is meeting in Mumbai, India, and for a number of reasons, my travel plans got canceled for that. So I am attending virtually, which means I am up from. I try to take naps, but I am up from 11:30 p.m. my time until 6 a.m. virtually attending these meetings, and I've been doing this since I guess Friday evening my time. So I don't even know what day it is, but technically I've already finished Tuesday in India. Now I'm finishing Tuesday here, and then at 11:30 tonight I start up again. So I'm pretty tired.
I want to ask you about the ICANN meeting in just a second. First, hey, David, how's everything going where you're at?
All right, weather's looking better.
Yeah, we're going to get rolling today. We got three cases, and there's also a fourth case in the news, basically domain disputes. But, Jeff, I wanted to ask you about ICANN. So I signed up, and I like attending the sessions. But, yeah, since this is in Mumbai, the sessions are really in the middle of the night. Um, Samit was saying he's over there in Mumbai, and he was attending in person. And he was saying that he was going to attend a GTLD session, and I'm thinking he meant today, which has probably already happened. So, did you already attend a session on the next round that happened earlier today?
Yeah, there's been a bunch of sessions on the new TLDs, kind of geared at different aspects. So today's session, which I actually had a conflict with, so because I had another registries meeting, so I have to listen to it. But today's subject was on the application system and kind of a walkthrough of, they call it TAMS, right? The TLD application management system, something like that. And so today, supposedly, um, about 7, 8, 9, 10 hours ago was a session on a walkthrough with that. So that's probably what he attended. I have to listen to it again or listen to it for the first time. All of these sessions are recorded, so you can just go onto the meeting site. You go meetings.icann.org. You click on the current meeting, which is in Mumbai, and then it'll take you to a page where you hit the schedule and you can see all the sessions that have been offered already so far and what ones are coming up. So there was another session on if you're a brand and want to apply for new GTLD, or if you are applying for an internationalized an IDN top level domain, so in different characters. So there's been different sessions all along, and I think the one tonight into tomorrow, or the one um, tomorrow night into the next day, is a session on like an overall session and one where there's expecting questions and answers. So that would be an interesting one.
Well, thanks for the reminder to everyone because it is something you can attend virtually. So that's the ICANN. Um, I believe it's ICANN 85. Is that correct? Yeah, ICANN 85. So, Jeff, there's three ICANN meetings now per year. One is the contracted parties, and that's registries and registrars. It's sort of like the focus
Actually, there's
on them.
four.
Oh,
There's
there's
four.
four.
That doesn't count. That doesn't count as an ICANN meeting. So there's a meeting in March, this one, which is called the Community Forum. I don't know why, to be honest, but it's basically um, a regular meeting starts on the weekend usually, and where there's working sessions. then ultimately ends on the last day with a public forum and a board meeting. That's in the March timeframe. Then in the June timeframe, there is something it's called a policy summit, where there's no like board meeting, there's no public forum, there's no welcome ceremony. It's just really for policy, strict policy work. And finally, there is at the end of the year is their annual meeting. So that's like the community forum, but then they add and they change over the board for new members to come on and old members to leave. So those are the three main ICANN meetings. What you were referring to as called a contracted parties house summit. So the registries and registrars get to attend usually in, well, it's been different times every year. Sometimes it's in September, but I think they're trying to move them all back to April, May. And this one this year is in Manchester, England. And that'll be April 27th, somewhere around there. So next month.
And not to get into it too deep, I should know this, but they're nominating some new board members, correct? I mean, there's a couple open seats. Is that correct?
Yeah, every year there's two openings or three openings depending on the year. So for two of the years there's three openings, and then the third year, which this is, there's two openings. But the openings are also available for existing board members that were approved through the nominating committee to reapply, and a board member can serve a maximum of 3 terms. So the board members this time that are, I believe, one of them is term limited, so she can't apply again. So that's a true open spot. And then the second one can reapply, and so she's going to reapply. I'm assuming, maybe not. So that may or may not be open. The nominating committee has had mixed results with approving, or I should say, reconfirming board members. They don't always do it, and that's angered some board members because obviously it takes a while when you're on the board to actually get used to being a board member and to assert yourself. So it's a 3-year term. It's not really till the second or third year that a board member is able to really participate. And board has to plan for successor leaders, like a chair. So last year they got rid of the vice chair. They didn't approve him for a third term, and they put someone else in place. And so the chair was not happy, and she let everyone know that she was not happy with the nominating committee. But the nominating committee meets in secret. I mean, everything is confidential. I shouldn't say secret. Everything's confidential. So the rest of the community doesn't know who applied or reapplied. At the end of the day, all we know is who they select, and they're pretty good about keeping that confidentiality.
Yeah, I remember, and I think so. Some of the people that are on that committee, like Jothan, you're allowed to say you're on the committee. You just can't really say anything about what you're doing on the
Right.
committee because he's
Yeah,
mentioned it a few times.
Yeah, it's publicly listed who's members of that committee.
Um, Interesting. Well, I look forward to listening in on some of the ICANN sessions. They are recorded. You can go to like I said, sign up to participate. Really participate as a listener, virtually. And I'm going to listen to some of the sessions and look forward to listening to the upcoming GTLD sessions. There's some that already have taken place, like you said. And Jeff, we've said, for several months, really through last year, we're going to, do something on here with regards to the next round, basically do a space dedicated to just, new GTLDs. We're really having, it's really heating up. A lot of work for us to do behind the scenes, helping companies apply. I think what you and I'll do, we'll talk about maybe here in March, when is a good time to have an hour session to clear up some frequently asked questions about the next round. And it's not too late to apply. It's not too late to apply, but the application window does open April 30th, so people really need to have their ducks in a row pretty much now. But if you are going to apply, you're listening to this on replay, you can reach out to Jeff at jjnsolutions.com. Of course, we're doing it through TLD Strategies, but really everything goes through JJN Solutions. So that was just, TLD Strategies was just a venture we put together to attract, make it easy for people to go to a dedicated website, but it's really handled through JJN Solutions. So now I'm just, cutting out the middleman and saying, if you have interest in applying in this next round, time has not run out, but it sure is getting closer to, time to actually put in your application. So you can send it Jeff at jjnsolutions.com, and we'll take it from there. There was a piece of news that I thought was really interesting.
Or Todd,
Yeah,
you can give your address
yeah.
out too.
And I have it. You can just send to me, TODD at jjnsolutions.com, and I did give that out on Saturday because Ish's show, he also records that. So anybody listening to replay, I mentioned on Saturday, send to both of us because now we're getting busy, and then that way it'll assure the fastest response, and just go directly to us. I wanted to say, so there's this interesting piece of news, and Jeff, you haven't commented on it to me yet, and I know you know about it, and David, I'm very interested in your opinion here too, because it really is a privacy issue. WIPO has announced that they're going to let people file a complaint, file a UDRP, and then they're going to give up the domain owner's contact information to the complainant, to the person who's filed the complaint. And then if that complainant immediately cancels the UDRP, they're going to get refunded all of their money except for $100. So the bottom line is, people, and especially brokers, really just companies that are interested in buying a domain name, and they cannot find out who the contact is, who owns this name, who's the true registrant because of privacy, on these on the registrations, on the who is. So basically, for $100, you're going to be able to get the registrant's information. Well, first, Jeff, I mean, I'm already thinking of some ways, not be abused, but certainly, take advantage of by entities just looking for the registrant information and not really looking to, file a complaint. But what do you know about this, and why do you think WIPO has put this into place?
Well, I think people have been doing it anyway, right? So WIPO has already, unlike the forum, if you file a complaint, a UDRP complaint, and then, when you file a UDRP complaint, you file it, and then what happens is the provider, in this case WIPO, sends an email to the registrar. The registrar validates who the registrant is and provides that to WIPO. WIPO then provides it to the filer, the UDRP filer, who then has a choice to amend their complaint or just proceed with the complaint as is. But it also has a third choice, and the third choice is to essentially withdraw their complaint, and then they get a partial refund. I'm trying to look up exactly how much the partial refund is. It certainly wasn't. It certainly didn't amount to $100, I think. So they've made it cheaper. But essentially, what they're doing really is just kind of codifying what they do in practice and making the cost lower to kind of upsell a service, which, as you said, certainly has privacy implications. Was not intended to do this, and so it's causing some controversy in the registrar community, as well as privacy rights and others, to just blatantly openly market this. Again, it's something that we've been seeing complainants do anyway to get that partial refund, but this is more blatant and cheaper. So yeah, I mean, I have mixed feelings on it. I think in general, offering the refund as they do today is certainly legitimate because, you may find out that the registrant, because it's always redacted, so you don't have the registrant information, you may find out that the registrant's last name is the same as your mark. And you didn't know that when you filed the complaint. But if you see that and you think, oh, I'm not going to win this case, complainants should withdraw their complaint. This is taking it a step further, saying, well, yeah, just file something that looks like a complaint, then withdraw it, and you can get it for $100. And so what people can do, like you were hinting at, Todd, is essentially create a templated UDRP form, file it for any name you want to know the registrant information, pay the $100, or then withdraw it and only pay the $100. And you can include up to 5 names in a UDRP complaint. Technically, they're supposed to be against the same registrant, but if you're going to withdraw it anyway, they'll never check that. And so, again, it's essentially selling the data for $100 or $20 a name if you do 5 names.
Yeah, and that's a good point. $20 per name if you do 5, and why wouldn't you? And there, I think WIPO will notice when people are intending to do it for those reasons, because you're going to see applications for 5 names, especially coming from brokers. David, how do you see this playing out, and what potential for abuse do you see?
Yeah, I see that this is going to be used to dox bloggers, and it's going to be used to game the UDRP ACPA system so they can figure out the weaknesses, the strengths and weaknesses of their cases before going forward, and maybe try to get the upper hand. So if they feel like they won't win on a UDRP or will temporarily, but then it gets appealed to, say, Arizona, they'll just go ahead and file straight in Eastern District of Virginia and skip all of that. Kind of like the big case we had from the last couple of years ago regarding a Chinese registrant who responded to the UDRP, and then the UDRP was withdrawn.
Yeah, David, your
So
audio's a little
this
low.
would be refunding the money. This would be prior to even a respondent responding. So it would, and I'm just looking on the supplemental rules. It's been $100 anyway. So the way they word it is early case termination prior to the case commencing, which is prior to it being sent out to the respondent to issue a response. If the complainant requests to withdraw its case before the case is officially notified to the respondent, WIPO retains an administration fee of $100. So it used to be you'd pay the, whatever the fees were for a single panelist, you would pay $1,500. And if you got the information and withdrew it, you'd get $1,400 back. Now what they're saying is, well, we're doing the same thing, but only pay us $100. I mean, it's the same thing as what they do today. They're just being more blatant about it because they see people, A, it's a way for them to make money, and B, they see that lots of people are doing this to get the real registrant information anyway.
Well, Jeff, how I'm reading it is they're still going to charge the full fee, and then they'll refund $1,400. I think before, you're right. What they're trying to do is be real clear and say, soon as you get the respondent information, soon as you get the domain owner's contact information, you need to cancel right then before we send the respondent, the domain owner, the complaint, and then we'll give you everything back but $100. Because I think it was
Which is
unclear
what they
before.
do today anyway. They're just now marketing it as a service.
Right,
sort of.
right. I think before they weren't clear on how fast it needs to be canceled, because otherwise, if you cancel after you can still cancel after the respondent, the domain owner, has received the complaint, but yet then I think you get, everything but $500.
About 500. Yeah.
I believe that's what it was, but for sake of argument, but right. So the thing is, if you filed a complaint in the past and immediately canceled it, but I mean, you would get everything but $100 back, and they're basically the nuts and bolts of this are, yeah. So what you would do is put in 5 domain names, file a complaint. The issue is you're still having to put up $1,500 before you get back you're 1,400. So I'm seeing some people that think, well, I don't want to spend the 1,500. I'll spend 200 and not get back anything. How's that? So I'll give you $200, and that's why I think, people that can file on behalf of someone, certainly attorneys, could say, okay, we got a $250 non-refundable fee, and we'll get you that way the attorney makes, or the person makes $150 for filing it, or actually they would make a, yeah, because the filer would get back everything but $100. So it would need to be somebody who has it in an account, not necessarily an attorney with a trust account, but you would say, okay, you give me $250, I'll file this for you, and then the filer knows, okay, it's going to cost me 1,400, but I'm going to be out 1,500 for the couple weeks before ICANN returns my money. So what I'm getting at is, yeah, I'm sure there's going to be some folks that say, I'd like to know the name of these 5 domain names for $100. Who's the owner of these 5 domain names? And I'll give you $50 per these, for each one, because right now GoDaddy charges, I believe, $60. There's other services out there as well that charge 100, some charge 20, but they basically charge you to investigate or try to find out who that owner is, to inquire about a name you're interested in purchasing. So there's already that fee out there. David, is it $60 that GoDaddy charges if you want to hire their broker service to inquire about a name? Do you recall what the price is?
It changes all the time. Last time I checked was 129, but sometimes it is 60.
Yeah, I've seen. It went up. It was 99 like a year ago, or $100. And then you're right, it's gone up, and I think it'll just continue to go up.
David, we can hear you clearly, but the audio's low, at least for me. Is that the same for you, Jeff?
A little bit, but not too
Okay,
bad.
not bad. Maybe it's just me. We'll get to our news and our cases.
Testing,
So
1, 2,
you guys
3.
know this is the Domain Name
Better
Law
now.
Show. Every
Yep.
week we talk about legal news, usually in the domain space, sometimes regular news, and mostly we focus on reviewing recent domain disputes, recent UDRP decisions. This week I had in the news, and we'll just brush over it, was ICANN was cleaning up there were some registrars that weren't paying their fees. Basically, they weren't paying their fees, probably not complying in other instances. And I saw it on DNW, so love to shout them out. Andrew Alleman over there, go to DNW. He's got some great podcasts, recent ones. I know one with Josh Reason, my partner on Thursday show, Josh, Domain Investor. And then also, I guess, Logan Flatt and Mark Levine just recorded an episode. So I don't know which ones have come out yet. I haven't listened. But anyway, always a shout out to DNW. Didn't they just celebrate? I think Andrew just posted, and I got to send him a message and say congratulations. I think he's been doing it 25 years. And that is, really fantastic, and a big help to the domain community. He's really the leader in the blog, sharing news with us, and he touches on everything, just whether it's some ICANN news, some legal news, just domain marketplace news, domain investor news, registry news. So that is really the cornerstone, anyway, the bedrock. Anyway, that's the main blog I consider for news for the domain industry. That's dnw.com. Of course, there's dnjournal.com, and with Ron Jackson, what he does there with posting sales and his lowdown, and it's more featured stories. And then I'm going to final shout out to domaining.com. Francois there at domaining.com aggregates all the stuff. So there's, plenty of sites from Shane's DSAD to domain investing that Elliot runs. A lot of these guys, they've been doing it. Everybody's been doing it 20 years. It's the same folks. Okay. And it's really fantastic. It shows, once you check into Hotel California, you can't check out. Okay. So, but the domain, great community. But anyway, I was shouting out DNW because they brought to my attention about these registrars. So, Jeff, just quickly, registrars and registries, it's not uncommon. Sometimes they just stop doing business. They stop paying their ICANN fees or complying with certain things. And then how long is it when a registrar just basically say they go out of business? How long before ICANN usually steps in? Is it a month, 2 months? I mean, so a domain investor can understand a little bit. If I have a domain with this registrar and this registrar just goes out of business, how long before ICANN steps in?
Well, it depends. I mean, if the registrar goes out of business and they know it's gone out of business, right? Or it's announced or something comes to their attention, then they'll act fairly quickly. But most times they don't know what's going on. So, someone just kind of fades away. And so the ICANN gives plenty of warnings. I think it's like, they'll three warnings. So they basically will write a letter saying, hey, you're deficient. Please, respond in the next 30 days or we'll, issue a breach. So I think that happens for a while. And then ultimately ICANN will send the notice of termination, which then gives them essentially, notice that they will be terminated, then finally the notice of termination, and then they send that to the registries to make sure that the registries turn off the registrars. So they give plenty of notice. I would say at least 120 days notice.
And depending on the registrar, um, if they have an issue or they're going out of business or their site's down, you're not going to lose your names as a domain investor. You may lose some access depending on their website and
Oh,
the dashboard, but
yeah,
that's
I forgot too. Part of the termination process before they get shut off is to do I don't want to say it's an auction, but it's kind of sort of it's other registrars will come in and say, yeah, I'll take over these domain names, and they submit a proposal, and then ICANN, I guess, selects the best proposal to who to transition the registrants to. But again, you can only transition registrants if the records kept by the existing registrar are sufficient. And so the problem is, yeah, they'll transfer all the data, but they may not know who the customer is at all. And that's a problem that the registrar needs to figure out, the new registrar.
that's interesting because like with Adam, new registrar, and I know Darpin's over at Mumbai, and it's pretty exciting, I would say, for him and the team, the Adam team, now that they're a registrar in the space, in addition to the other, being a marketplace and so on. But being a new registrar, and I know Josh at DNX is soon to be a registrar. I'm wondering how attractive it is to pick up, to bid on some of these defunct registrars, especially you see they got, whether it's 500, 5,000, 50,000, 100,000 names. Um, how,
But there's always a question. There's always a question as to how legitimate these names are, right? So with Epic, yeah, right, when they initially were going out, um, obviously someone ended up coming in and taking over. But Epic had a lot of real names. But a lot of these registrars that go out of business, a lot of them are junk. A lot of them are just warehouse names, or so really registrars need to take a look at how real these registrations are.
no, understood, and they need to evaluate what really is there. But it certainly is a way to get 10, 20, 50,000 names. I mean, if you have to pay for them, of course, but I'm curious, if it's worthwhile. I'm going to talk with Darpin about that, if he's even looked into that or considered that, thought about that, because when you're a new registrar, you're just trying to get some domains under management. And Josh the same. By the way, yeah, Josh and I do the show on Thursday, DNX show. Got a big list of domain investing topics to cover. So that show is for domain investors. Basically, we're putting money into these domain names. We like to sell them, really anywhere directly, but various marketplaces. So that's what the focus of DNX show is on Thursdays, just so you know. This domain name law, we're going to jump right into it. Our very first case is really just a news story. So we're not going to dissect this as much as our three cases that you see in our show title. Those three cases, caresoft.co, liquid.app, and ORCID, we are, sort of review a little more in depth. this first case, I would like to, but we just I'm going to really almost throw it to David. I'm sure he's done some research and looking at this. It's a case I really wanted to cover, but more than 3 cases is just too much for us anymore because we can't really, get to these. So this first was in the news at Domain Gang, and another fantastic blog. Like I said, and Theo's been around for fucking 15 or 20 years, excuse my language. All the main players, basically it's like I said, we're going to a running group. It's the same people. You either, stick around long term here. We don't see a lot of short term people. Of course, we welcome everybody who came into the space in the last 10 years, in the last 5 years. But I think you'll appreciate a lot of the people that, provide information and are doing research, people that have been around for a long time. But anyway, so domaingang.com, Theo had an article saying, hey, this domain NatureG, NATUREGY.com, was part of a UDRP. It was in the domain, it was the disputed domain. This company, NATURGY, was the complainant. They're on NATURGY.com. Big Spanish energy company. And so they go after this domain. And when I look at NatureG, of course, yeah, you see nature, and NatureG just seems like a cool brandable. And then I realize, yeah, it's like nature and energy together, which fucking really makes sense, right? Natural energy. So I really like the domain name. David, tell us a little bit about this case and eventually what happened with it, and then we'll roll into our showcased cases for the day.
So the respondent was an Indian domainer and website developer. He found the name expired on expireddomains.net, and he thought the name had value. And maybe because in India in 2022, there was a trademark registration for NatureG spices. And so it was in commercial use for a while. I'm looking on security trails and shows that it had a history of 5 years. It was first registered in 2021. I think the decision mentioned that it came in before then. It was being used by others before then. So it has significant history. Now, I never heard the complainant. The complainant thinks, oh, yeah, they're one of the biggest brands in Spain and they're in 20 countries. Yeah, but those are like small countries in Europe and South America that I'm not familiar with, and I don't think a person in India would be familiar with. The guy in India says, I Googled the name, I didn't see the complainant. And the panelist said, oh, I used DuckDuckGo and it came up for me right away. Well, that doesn't mean anything. And if you're going to use DuckDuckGo, why don't you go to WIPO Brand Index and you'll see the registration for NatureG spices out of India. And then you see, oh, okay, so this was not a typo case. This was a legitimate domain that had some backlinks and it was worth something. And that's why he acquired it. It wasn't to target the respondent. And he had a lander at Atom, because the DNS still shows the Atom DNS. So other than that, that's generalized targeting. It's not specific targeting. It's not allowed. And the panelists basically made a bad decision. What do you think, Jeff?
Yeah, I mean, I think there's certain panelists that love the willful blindness argument, meaning that if you're a domain investor, especially, that you need to do some searches for the names that you that you want to acquire, and it's not equally applied amongst all panelists, but certain panelists in the trademark community, they are more susceptible to do that. So I think what they said is, look, you searched your misspelling, but you didn't do a broader search for like the correct spelling or the branded. And I think there's a quote in there that says like doing such a narrow search is no better than doing no search at all. I don't know if I agree with that, but again, there's a burden put on especially domain investors when you buy up a name. If that's your business, then you need to, they're not saying you need to do trademark searches necessarily, But, if you put in a real search in Google and it only comes up with the complainant's mark, that's an issue. So I see both sides of this. Uh, and I'm not sure I would have decided the same way, but this is Andrew Lothian, who is always, he's used to representing brands.
Anyone can see the case at dnlshow.com/outline. There's a link to all the disputes. Okay, so this domain name, naturegi.com, was transferred away from the domain owner, and basically the panelists said, this is not a dictionary word, this is not an acronym, this is not, this is a made up word. Okay, this is not in Andrew Lothian, the panelist, did say, um, he did say, yeah, this is, you say brandable, the respondent, the domain owner said this is brandable, but Andrew Lothian acts like, what do you mean by that? You need to explain what you mean by brandable. Well, um, I don't know. David, what's the name of that when you put two words together? Rochambeau, Kathmandu, it's something like that. What's it called?
Portmanteau.
A portmanteau. Okay. Okay, so I knew that. Anyway, so that's exactly that's what the respondent is saying he did here. But it's sort of like, so the whatever that panelist is saying, yeah, if it's a dictionary word, I can understand you registering it. If it's an acronym or these short 3 or 4 letter, I can absolutely. But if it's brandable, you got to explain to me what's brandable. And it's like, okay, these guys in Lothian, he's done so many cases, and it's not like, I'm assuming, Jeff, all you panelists, when you're not in the thick of having to, decide one of these cases, review the complaint, weigh it against the response, and, outside of that, we know you're very busy, but you're also thinking, you know what, since I'm deciding these domain disputes, I'm going to maybe learn more about the domain industry. I mean, over the years, how could these guys not know there's marketplaces? Of course, there's domain investors, because they sure learned there are domain investors who solely buy names to sell them. And now they're trying to hold domain investors to a higher standard than the average domain registrant. So if you're an investor, you need to really, do some research. And how much research? For one, domain investors, we talk about it all the time. And I said on the Thursday show, Josh talks about it. How many extensions is this domain registered in? 60. Well, that's a lot. 130. Are you kidding me? So we love to see domains as domain investors registered in a lot of extensions. Well, we know automatically if I see it's registered in 50 extensions, I'm assuming this. Probably, I'm just guessing myself, probably 30 or 40 of them are just registered, probably not even developed or even going anywhere. There's probably 10 of them that are companies using that. I'm saying that's if there's 50 that I'm noticing are in other extensions. I'm probably thinking, yeah. And those ones that are developed out are actually sites using that term that I'm talking about, whatever it may be. Well, yeah, I'm not even looking at the USPTO. They may have a trademark in some other country, but I'm not looking in other countries either. I'm thinking if they're really doing business, I'm smart enough to know they have a common law trademark. So if they're doing business at it, fine. But I'm just a domain investor. I'm happy that people like to use that term. Okay, and this is not a term like Coca-Cola or Pepsi that's super famous and is so fanciful, that crazy word, right? So unique that you really can't touch names like that. But Naturgy is the name we're talking about. The company that was the complainant, naturgy.com, right? An energy company. They go after naturegy, and it's just a terrible decision, I think, for us domain investors for a couple reasons. One, I think should have been, I guess, a better defense. Had a domain lawyer there to really help out and explain what a brandable name is and what portmanteau is, and just give other examples, and that it really is a combination of two words that really mean something together anyway. It'd be one thing if it was two words that didn't even go, but natural and energy. So just a bad decision, and that's just to get the audience ready for a bunch of decisions where we're just taking away your domain names. So the UDRPs today, I just can't help myself. Well, I'm not going to give away all the decisions, but maybe you'll take the hint. But so that domain was transferred away from the domain owner. Whether he's going to try to do anything to keep it, who knows? So we'll go on to our first case. Our first case today is one that's just flat out ridiculous. Caresoft.co. Okay, caresoft.co. I was lucky enough to talk with some other, domain attorneys and some panelists about this case. So, boy, I felt lucky to do it. Anyway, so got some insight from some other smart people who are in this space and their thoughts on it. Pretty much, everybody's the same. Anyway, so the domain caresoft.co, Caresoft, sounds like two words to me, Caresoft. The complainant in this case was CARAHSOFT Technology Corp. So Caresoft, and it's Cara, CARAH. Okay, this complainant said this domain is, really, they registered it to confuse people to think they're us. So they're misspelling our first part of our domain, or our first part of our company name, CARAH, with this word, CARE. I mean, it's obvious they're trying to misspell CARAH with CARE, which right off the bat makes you think this is just ridiculous. This panelist here, David Kreider, who transferred a name away from friend of the show, Igor, who I forget the domain it was, but a bad decision. I felt like it was a bad decision. Made another bad decision here. I'll go, David, why don't you chime in on this? Tell us a little bit about, if you recall, this Caresoft is out of, I believe they're right here in the U.S., maybe over here in like on the East Coast somewhere. But yeah, I remember
Yeah, they're in
because
Maryland.
Nat Cohen told me he never heard of them. And because we were talking, we hate when names are transferred away from domain owners. But go ahead, David. Tell us some facts about this one.
Yeah, so Caresoft it's a .co registered by a Serbian guy in Serbia. So he would have no way of knowing about this company. I had never heard of this company. The name the company has is ridiculous. It should be like correctly spelled. Why are they making up words and making up multiple syllables? It's just bad from a branding point of view. Interestingly, there is caresoft.com registered and listed on Atom for $53,000, and it was registered in 2003. So this guy has some issues, but here's the real thing. If the respondent had said, look, it's not a typo of Caresoft, it's a name that matches at least 95 active corporations around the world, and here's a list of them. Go to Open Corporates and search Caresoft, and you'll find them all. And before that, I think there was 217 altogether, but some went out of business or some were just branches and stuff like that. So it's a bad decision. And you know what? Zach wrote something on his blog today saying that UDRP isn't just a similarity test. Bad faith requires strong evidence. A respondent targeted the compliance mark at registration. If the disputed name is coherent and independently attractive, panelists should be cautious inferring targeting from phonetic resemblance alone. And I think that's the issue in this case, phonetic resemblance. And I think it's the same issue in the previous case with Nature-G.
Yeah, I have questions. Jeff, what do you think about this? I mean, Caresoft, David said it's registered in, there's so many other companies that have a trademark for that term. If you're, as a panelist, what if you said, so you're targeting all those or any one of those? Is that still wrong? I mean, how do you use that defense that there are other companies?
Yeah, I mean, that's the worst part of this decision is that the panelist says that there's no plausible use of Caresoft that wouldn't infringe on Caresoft. And then, as David said, you kind of do a Google search on Caresoft and you see dozens and dozens of companies that use Caresoft for a whole bunch of different things. So for a panelist to say there's no plausible use Yet there are dozens of companies that do use it. That's just wrong, right? And it completely undermines, the fact that they say it's a typo squad. It undermines the legitimate rights and interests because, again, to be so biased as to say there's no plausible use of the term when dozens of companies are using that term, it's just inexplicable. And the fact that the panelists didn't do a search on Google, its own search on Google, right? They expect investors to do searches on Google to see what's out there, but panelists don't have to do searches on Google, and yet they can make a statement like this. Yeah, this is one of the worst decisions. This would certainly make my top 10, the
Yeah,
worst.
but and what you're saying makes a lot of sense, Jeff, with regards to the panelists. Sometimes they're like afraid to do research, but they can be knowledgeable about the term, about the dispute, but fair. So it's not like, oh no, I found out. I mean, the panelists are generally smart, meaning, okay, you found out that there's more, um, maybe more uses to that name. There's several different trademarks. Some of them can be senior to the one that the complainant even has. You still don't have to, put your finger on the scale for the respondent saying, I found some information, so the respondent should really just, and then once you're knowledgeable, then look back at the evidence and say if the respondent didn't submit evidence showing this, although I do know this, it's not that you're going to use it to benefit one side or the other. It's really just verifying evidence and making yourself more knowledgeable about the terms. Because as David mentioned, that there's, a company in Serbia may not, sometimes I forget there was a term Josh was mentioning. It's like caregiver. Oh, carer, Carer, is what they call sort of caregivers over in the UK. Well, it's important to know when we're talking about word disputes. That's what a domain dispute is. It's a dispute about a term, a word. So different meanings around the world. So it's smart for a panelist to make themselves familiar with a term and then to say, right, Caresoft, I can't imagine that being used for anything other than Carasoft. Is just silly, just wrong. It's stupid. And it really, upsets you as a domain owner because you're thinking, oh, you get the wrong panelists, they come in and make the decision for you. What I would recommend to domain investors, if you get a dispute, reach out to a lawyer that knows how to handle it. Okay, but outside of that, if you're handling something yourself, and I'm not an attorney, so take this advice with a grain of salt, is when you're saying, hey, there's 50 other companies that use this trademark, that use this term as part of their mark, it's I think not equally as important, but also to say, and there's so I believe there's a likelihood that there's going to be future companies that also would like to use this term because it's used already. So you're not just saying, I hope one of these existing companies buys this domain from me, because we've seen in a couple cases where they consider that targeting. If you're targeting a whole group of companies, even then you could say, because there may still be some open categories where a company could use, every category. Somebody loves to use the word cheetah or something like that. So it's just important to, when you're saying there are plenty of other users, there's probably plenty of future users as well. That's just my thoughts. I don't even know. Okay, so Caresoft, Caresoft.co gets transferred away from the domain owner, and David even said Caresoft.com's for sale. Why don't they file a complaint against that? Because it doesn't have a registration date that is after the trademark, and so many times when you're buying on the aftermarket, you get that an expired name, you get that new registration date, and believe it that panelists are using that date as your registration date, because sometimes it is now that acquisition date. And even if it's got the original registration date, many times the panelists will use your acquisition date. That's the date that you got it. That's the date we're dealing with. And And well, I'll get into the next thing about, you need to, they're making you really not only do research as a domain investor, but you better put this thing to use real fast in a legitimate fashion, because when you don't, that they hold that against you as well. So caresoft.co is transferred away. Our next case for today will really upset you. So get ready, sit down. Liquid.app, liquid.app. I'm really starting to love this. I'm going to talk about it on Thursday, the .app extension. It's used a lot more than people that I think domain investors realize. Maybe they do realize it, but we're not seeing a lot of sales reported in it. So domain investors, that doesn't, when it doesn't get their eye like that, but I'm seeing a lot of companies use the .app. So this case, this company acquired, well, liquid.app was the domain in question. The complainant was on liquid.ai. That's their company, Liquid AI, Delaware Corp AI company based in Massachusetts, in Cambridge. Sounds like real smart people up there. Okay, so and I'm not a big fan of Massachusetts. Okay, anyway, especially Boston area. Okay, so Sam, um, the respondent was supposedly Sam Sharma. He's the registrant, but weird case where he bought the name on the aftermarket and he immediately entered an agreement with this company, Liquid App. Okay, so Liquid App was like, we want the name liquid.app. So 2 weeks after Sam Sharma picked up this name, he enters into this agreement with liquid.app, and they come into play because they are responding to this UDRP, because they're saying we have more at stake with regards to this name than Sam, because now we've entered an agreement with him and we're building a company on, it's called Liquid App. And our company is about, in the finance sector, it's not in the AI sector, it's about liquidating your assets. So we all know, we talk about domains aren't liquid. But so it really makes sense to me, the Liquid App use, even more than the liquid.ai. But anyway, so we all of us, I think, are smart enough to understand, certainly several different companies could use the term liquid. And of course, if it was used as a drink, of course, then that's such a description of it probably couldn't be a trademark that you could actually get registered, because it's so descriptive. But you could certainly have bicycles called Liquid if you were, in that sector, or as this company's doing, Liquid AI, and then as the respondent, Liquid App is trying to do, is do a finance company that helps you liquidate your assets. All right, I'm about ready to go to you, Jeff, but I'm going to say, so Liquid App, this respondent, the panelist said, okay, well, I'm going to consider you and that owner you're in an agreement with, Sam Sharma, as the respondents in this case. And, they did rule it's identical to the complainant's mark. And a key here was the logo. So but when you have logos for a term like liquid, it made me think of when I see companies do logos for honey. You know how everybody's logo looks the same. It's a bee on a hive. It's a bullshit. So liquid, when you see a drop, it made me think that's not so uncommon. But there was a few marks to the design that they did look pretty close. But that was really the only negative thing I saw with regards to the respondent's response, was their use of this logo. Go ahead, Jeff. Tell us some facts that you saw in this thing, and share the answer, which I've sort of already shared.
So yeah, it's pretty similar. If you look at the decision, So the way the lettering is on Liquid, it's a copy. It's a definitely a copy of. It basically took the complainant's website logo and inverted it. So the complainant's website logo is white with black lettering, and then if you took that and just reversed the colors and made it white or black with white lettering, that's exactly the
Well,
mark
and
of.
Jeff, I wanted to say quickly, right? They said that even on the complainants' Facebook pages, they had, that black background, so it was almost identical. There is a small curvature to the one, so it's just so slightly different. But Jeff, I will say AI. When you say create me a logo, it wouldn't be uncommon for AI to come up with almost these similar logos. So I'm not saying that sure it looks identical, but I would be willing to bet when you go to a logo maker for the term liquid, it's going to come up with a lot of similar logos. This one seems, obviously like they may have just looked under liquid, under images on the internet, saw this company's, and this might have been, at the company's website, but it might have been copied somewhere else, and they thought, well, look, this is just artwork, and I'm going to take this, and didn't realize that it was actually somebody else's art, but it certainly got them in trouble. That is the only thing in this response, basically, so the panelists held that against him. It's obvious you knew about them because the logo's the same, so I transfer the name. Well, tell us a little bit about, and then you, David. There was more to the response. They said, "Here's what we're doing. I mean, we're a real company," and um, well, go ahead, Jeff. I mean, there was more to the response that I think was solid, but just didn't sway the panelist.
Yeah, but I mean, I think there were the uses that the respondent was claiming, saying we're a real company and this is what we're going to do. I think was similar, if I'm not mistaken, to what. So what the respondent was going to do was in the similar same area as what the complainant does. And so that I think was, they're both too in the high tech and,
Yeah, one was AI,
whether
but one
those are
was financial liquidation of assets. So there was a
right. But
difference.
there was a little bit of a difference. And I think, um, again, I think with the copying of the logo and, even if it was AI generated, then and to put it as app, I don't know. This one doesn't bother me as much as the Caresoft one does.
Well, David, tell me, still that word liquid. I mean, geez, you own liquid dot any extension, you'd think I'm safe. Okay, I made a mistake and I somehow found a logo online. I used it and it was at one of the other, because I'm sure liquid is registered in 150 extensions, and all of them, probably many of them have logos. You search a logo, and boy, you better not pick out a wrong one. But I guess the point is, liquid being such a obvious dictionary word, David, what kind of defense, could they have had to keep their name?
I would have mentioned that they probably both use the same AI services to generate the logo. And if you don't give the AI enough direction, it's going to go towards the mean of what it finds online and what's previously generated. And so it's going to regenerate what it generated before. There's a reason why there's no copyright rights in AI generated content, and this is it. Because these AI systems are generating almost the same thing for everyone, unless you give us detailed directions, specific detailed directions. And I tried just doing a prompt now, create a logo for the Liquid brand using a high-tech theme for a crypto finance company. And it gave me a different logo altogether. So they definitely did not use Gemini, but they could have used, there's many companies out there that could have, I'm not going to speculate which particular service they use, but they probably used both the same service, and the respondent would know which service they created or used, I should say, to create their logo. So yeah, and so now what happened is the Liquid App Company has decided to file an opposition to the Liquid AI company's trademark in the USPTO. They filed for an extension back in, I think, December last year, and they filed the actual complaint in January, and now there's been an answer. And yeah, and the answer, they go, oh yeah, our logos are the same. Okay, but you're in different businesses. And they're saying, well, the respondent's saying, oh, there's no confusion between the services, so this opposition is meritless. Well, that's not what you said in the UDRP. So contradictory stuff there is going to come back to them. I think there'll be litigation over this case.
This panelist said, you claim that it's coming soon, but I see no demonstrable preparations, to creating this site. And that's the big deal. So they constantly say this. They don't like to see a coming soon page. I'm telling you domain investors what panelists don't like to see. And it's just surprising to me. It takes so long. Many times you buy a name, and I was, when I see some of these companies that are saying we agreed with the domain owner for this name, they may be leasing it, maybe some other terms, and now we're working on it. There's more to building a business than just hurry up, throw up a site. So many times people will put join the waiting list, or here's briefly what we plan on doing, and I guess, in a UDRP, behind the scenes, all that work you're really doing, you need to submit that as evidence. So you could say, I know on the site it says coming soon, and you might not see that, it might not appear that we're preparing too much, but here, Mr. Panelist, fucking let's, we got to bow down to you and show you everything that we're doing. And you really need to support it with, a lot of strong evidence, because a panelist can just take that asset. And of course, in some domain rooms, these assets, man, the domain, that's more important than anything. That's the name. That's like taking your child's name away. So it's such a valuable, important asset, but yet, you really need to, and this really goes more for companies that are planning on using it, because domain investors, we usually don't even put a coming soon. We just put a for sale lander with a price. So it's real clear. Yeah, we're trying to sell this thing. That can get us in trouble as well. But really, the coming soon lander, that's not safe. So you're a real company. And anyway, it's funny that I think a panelist, it's like another business person telling me, you better hurry up with that. You don't even know what I'm working on. This may be something that's very important to me, but I'm making sure that when I launch this, I do it right. I'm not in a rush to do it. But you need to be, for a UDRP panelist, and if you're not, they'll hold it against you. But like I said, you better, I don't know, you can't just say this is on my to-do list, because they need to see some preparation. Basically, domains are just a weird asset, but as soon as you get them, you better do something legitimate with them, because I've always felt like, and I mentioned this to some of my friends that are panelists and lawyers, that yeah, in the old days, I used to think it was first come, first serve. I registered the name before anyone else, so I get the name, and I promise to myself and to the rest of the world, I'm not going to do anything inappropriate, illegal, infringing on anyone else. So knowing that myself, that I'm not going to do that, I have the rights to any domain name, because if I have, First Amendment free speech rights, even to someone else's mark, or maybe fair use rights to someone else's mark. Basically, when I buy a domain name, my intention is to never put it to use that would infringe or confuse or anything like that. So I always felt like that was enough, but that's not enough with the UDRP. You have to show demonstrable preparation that you actually are doing that. You can't just say it. So it's a pretty big deal. Okay, I love hearing myself talk, obviously. All right, so that was liquid.app got transferred away. So the company Liquid AI, it's like, that's fucking great. So we got that name. I would be walking around my office right now. Okay, we got that one. Watch it. I'll go out on the street, see somebody using the word liquid. Watch, I'll take it right from you. It's just such a, dictionary word, popular dictionary word. They're just bad decision. I would just need to, if I was a panelist, need the complaint to be so strong. And I understand about that logo, but that was the only thing that they just focused on. Like, that logo's identical. And like David said, maybe they use the same AI. But finally, my final point is, many times, and I've done it, search the internet. You could have told the AI, search the internet for logos that are, artwork, artwork that's created for, related to the word liquid, and find me artwork that is not copyrighted. And like David said, you can't copyright AI artwork. So how do we know how that was created? So I would want the complainant, if I was a panelist, to show when you created that artwork, by the way, that maybe the USPTO accepted. Who created that for you, and give us some evidence of that. All right. So anyway, that was a transfer. So far, 3 for 3 transfers. natureg.com was transferred. caresoft.co was transferred. liquid.app was transferred. You got to be feeling pretty good if you're a domain investor, huh? Come take your stuff right in front of you and walk away. That's how we used to do it. Take your stuff. We'll just walk away. Okay. And the last case, orcid.com. Really interesting case here because the domain owner is, we see them. Oh, by the way, I see Brad making a face. I wanted to mention something that we're going to talk about next week, Brad. David touched on it. You cannot copyright material that AI creates. Well, that's pretty big. Okay, David brought that up, several weeks ago. Brad sent me a link on LinkedIn with an article about that, and it's interesting and it's important. So we'll I think we'll try to touch on that next week. But thanks for always sending me stuff, Brad. All right, so the final case, ORCID. The complainant in this case is this company. It's called, what's it stand for? I'll get it somewhere in here. But anyway, it's important because, hold on. Okay, it's important because it's an acronym for something. So the company really uses orcid.org as their website. It's a long acronym, but basically this company gives IDs. It issues researchers IDs, whatever that means. But it is a real popular company. You search ORCID, and this company comes up on page 1, page 2, page 3. Not a lot of other. There's other companies that use ORCID as an acronym, and it sounds like misspelling to me. And when I was looking at Orchid, Orchid, and Orca, wasn't Orca a whale? Orchid, but Orchid is spelled with an H, right? ORCHID. But this could be considered a misspelling. But this company became very popular. It's been around for, I think, just only about 15 years. 2009. But very popular. And I think if you go to orcid.org or you search or ORCID, you'll recognize this company. You'll think, you may not have ever used them, but you'll think, this somehow probably been on your radar before. But only once you've, searched it, done a little research. The respondent, the domain owner in this case, Mira Holdings, domain investor, been part of many cases. One recent was Temco that the gentleman lost in the UDRP, but he has over 10,000 names. Has many times he'll use some of the well-known lawyers in the space to represent him in his disputes, from John to Howard New. But anyway, because I was looking at some of his old cases, oftentimes will represent himself. Very familiar. No one knows his names better than him. And in this case, the domain investor represented themselves and said, I have 10,000 names. I bought this name. I think it was about $6,000. Let me look, but he bought it on an auction and had it priced at, let's say, $60,000. I know I'm close, but had it priced at $48,500. And that was, at the high end of some appraisals that he had. But long story short is this, complainant said, listen, we're well known. You search ORCID, we're well known. Okay. And there's no way this person couldn't have known about it. And even though the respondent had, I think, a good response, it was the strength of the complainant's mark when you search it that made the panelists think, geez, how did he not known of this? More so, the panelists said this guy's a domain investor with 10,000 names. He really needed to do some research before he decided to spend $6,312 on this at a namejet auction. So if he would have done any research, he would have said, oh, I don't want to get this because this company's so well known with this coined term, which is no dictionary word. That's what the panelist expected the respondent to find. But anyway, David, what do you think of the response here? Yeah, I thought it was pretty good, but it wasn't a winning response. What comments do you have on this case?
So the name was actually registered in 2001 and the trademark wasn't applied for until 2011. So it predates the trademark owner by 10 years. And there's also other companies out there that use the name, like for example, Dish Networking, and they applied for 3 trademark applications for Orchid recently. There's an AI service with a correctly spelled version of Orchid, actually called orchids.app, and they would probably benefit by having the correctly spelled version. Sorry, they would have this would be actually a typo of their version of their name if if they wanted to get a .com. So yeah, I don't think the decision is good. I didn't really analyze the response, but I analyzed the history of the name, and I don't think that there's any evidence of targeting. It's listed for sale on Afternic. And yeah, Miro Holdings has it registered out of Turnbright Commerce, which is out of Colorado. So there'll be ACPA action over this decision. It's a clean 5-letter domain. It's a good one. It's investable. What do you think, Jeff?
Yeah, I mean, I think this one was probably a little closer than some of the others because when you do a search, it's so prevalent. The nonprofits, well, I guess it's a for-profit that owns a not-for-profit that uses ORCID or ORCID. I just think that it's so prominent on Google that I think that's at the end of the day what lost the case for them. But it's a close one, and I think I don't know how the under the ACPA that case will go, but if it goes, but like I said, it's like for me it was just how when you do a search how it's really this exact version ORCID is really used and well known within whatever industry or they use that in.
Yeah, I wanted to say quickly,
Yeah,
and
so the
then
respondent says
go ahead,
go ahead. The response says he acquired the name in June 2022. So that's interesting. So that probably gave the UDRP license to transfer it, but that'll be overturned in the ACPA case.
Well, I hope so. Before we go to a guest, David, who joined us on stage, nice to see you, David. Hold on. I wanted to say this panelist said that, or I'm sorry, the domain owner said, I didn't know of ORCID, and I saw it coming through on the expired. He's saying he didn't know about it because he didn't search it. Because, right, if you do search it, you're going to find it. But then the panelists are now saying, well, you're a domain investor. You better search everything before you buy it. And this domain investor was saying, this is a 5-letter, it's a misspelling of a flower. There's several reasons why I would want to, pick this thing up. But because, panelists now are feeling we're obligated to do a search of, if you're a domain investor, you need to really investigate who, is there a trademark owner using that term. And finally, I'll say before going to our guest, David, this when this domain investor bought this at NameJet auction, about a month before he picked it up, this company, ORCID, who's the complainant, was contacted by somebody saying, hey, do you want the name ORCID.com? And it was likely, we don't know for sure, but likely a front runner seeing that it's for auction, searched and thought, geez, this is a big place that could certainly use the .com. They're on the .org. Reached out to them. The complainant thought it was this respondent, Mira Holdings, but Mira Holdings. So we didn't even have it in August of that year. We didn't get it till September or so on. But um, it's a topic I think we may touch on sometime in the future about these front runners and how what is just ethically wrong and what is illegal. But anyway, before we close down today, I want to welcome David, our guest who just joined us on stage. David, what comment or question do you have?
Hi, Todd, and everyone else. Nice to be here. Uh, without too much length, if people are going to start taking that route, that you can compare ORCID to ORCID, then millions of domains are at risk. ORCID and ORCID have nothing to do. ORCID is taken in over 50 extensions by itself. So now you can start claiming that all these people are trying to go after ORCID's business, and it doesn't make sense. And I just don't know. The other thing you said, that people must have something parked in their domain and show a use or a coming page. Well, domains can be for sale. Huge Domains has over 4 million domains, and they are just for sale. So every once in a while that somebody tries to go after them, I think that I have never heard a Huge Domain lose a UDRP case. I wanted only to mention two things, really. Naturgy, without the E, is the name of the electric company in Panama. And I do believe that Naturgy is in 3 or 4 other countries. That's the major electric company known as Naturgy. And the last thing, if you would like to touch only a couple of minutes, what you guys think about being able to do a UDRP for $100 to get the privacy registrant information from any domain, or do a WIPO for $20 and also get the registrant's privacy information? This is crazy. I don't know what you guys think about that, but why have privacy if anybody can pay $20 to get your privacy information? Thank you, Todd.
Yeah, thanks, David. You must have
Yeah,
been to
so
the
regarding
tavern
that,
earlier. We did talk about that. Go ahead, David. We said, yeah, people are going to do that. You can do 5 names, for $100 and get the registrant information right from WIPO, and then basically that's it. Go ahead, Dave.
yeah, so if you're going to go ahead and do that, and if you start targeting the wrong names or doxing people for the wrong reasons, you could actually end up being sued. So there are privacy violations and under EU law, Canadian law, US law, First Amendment privacy rights, especially for bloggers. Yeah, you can't just start doing that willy-nilly. But even WIPO might become liable if they become super successful. If this encourages, say, 100,000 UDRP complaints a year, just so they get the cash flow through, and they're making $100 on each one, that's now an enterprise, and that actually takes away their sovereignty rights, and they can be sued in U.S. courts.
Well,
So
go ahead.
that's change.
Well, David, and Jeff, we'll have you comment, and then we'll welcome Christopher to have his comment. But David, I wanted to say, yeah, I think WIPO would be the one liable, most likely, for giving up the information for that price. Now they're going to have their defense, but then the person who receives that information, depending on how they use it, certainly they could be, they use it in some places just contacting someone. It might be a no contact law, but certainly doxing somebody, if they do it in a public sense, then they run into other laws, maybe some, doing things illegally. But I would think WIPO would be the one supplying that private information for a fee. You'd need to look at that closely. But Jeff, any thoughts on that?
No.
Yeah,
Sorry.
yeah, and we went over this. We were going to touch on these things
Yeah.
again, and David, listen back to the beginning. This is David, our friend in Panama. Please, David Roth. Please, I just doxed him. Please listen
Thank
to
you, my friend.
listen.
I will listen to it. I came afterwards, and I
Yeah,
didn't know you were talked about it. But it is a real issue because somebody may have a fantastic domain that he's waiting to sell at the right time or develop it. And on that name, you have 200-300 trademarks. And now any of these people want to know, well, who owns this domain that it would be great for me? And now they go pay $20 to find out who owns that domain in reality, under whose name it is. And that discourages the whole purpose of having a domain under privacy. Thank you, guys.
No, absolutely. And David, how many brokers have spent years trying to track down owners and just can't do it? And it's frustrating. You don't think they'd go, I have more than 5 I'd like to know. So here, let me do these first 5 for $100. So, I mean, I absolutely seeing brokers doing it. Then brokers will do it through maybe their attorneys and so on. Okay, Christopher, thanks for joining us on stage. What comment or question do you have?
Good afternoon, Todd, Jeff, David. Thank you very much for letting me come up quick for a quick comment and question here. Just wondering your opinions on whether or not you believe that going forward with a lot of these changes that we will see maybe some type of insurance policy or a different kind of service emerge, almost like a UDRP shield or something that where if it's now going to be easier for people to kind of unmask who owns things, will there be opportunity for people to step in and, you know, maybe like almost like a PO box where you have a PO box that you register so nobody knows where you live, your address, some sort of service like that, or some sort of insurance policy that you're shielded from any type of UDRP cases, and you know somebody reviewed your domain name, something along those lines, because I feel like there could be opportunity for that, or you know, obviously not for me, but you know, for somebody to do something like that. Do you think that's possible, or would be the case?
Well, I'll let these smart guys answer, but yeah, Christopher. So there's already, you know, a privacy that comes on domains, but then all these registrars sell this additional privacy. So that's exactly what you're talking about. They sell an additional privacy service to make sure that people cannot, in various ways, find out who owns this name. So when it comes to the UDRP, right, this is an ICANN sort of approved process, and they approve, of course, who are these service providers who handle the UDRPs. They're the ones that are ICANN knows the you know, the registrars know who the actual registrant is. So, and one of the rules is you must be honest about, if you're the registrar of this name, if you have fake registrant information, or somebody, you're saying somebody else is the registrant, they can take it away for that reason. So in this case, there already are sort of privacy shields, but this is a way to really lift all those privacy shields off, because it's sort of it's not legal, but it's an administrative process where, you know, they can force a registrar to come clean and let us know who claims to be the registrar. Because I'll finish by saying, Christopher, somebody could certainly say, hey, come to me and I'll register your names and they'll all be in my name, but you can use them. So when anybody finds out, they'll just think it's me or my company. Well, that can make a registrant run into problems, because they're like, if you're really not the registrant and you're using somebody else just to say they're the registrant, that's reason enough for your name to be taken away. Jeff,
Yeah, that's
go ahead, Jeff.
I'm sorry. I was just saying that's kind of what I meant. Almost like another sublayer, almost like a registered agent, you know, goes and files for, you know, your corporate filings in another state. And, you know, if you're in like Wyoming or Nevada, you have, you know, it's anonymous, right? Your agent is the one filing for you, even though it's your corporation. So I was just wondering if they make it that easy for $20 to pull the mask off of people that are that own names, how long will it be till those people kind of congregate and say, you know, we have to pivot and do something different?
Very good point, Christopher. Registered agents is a great example. Jeff, can someone use a registered agent as their domain registrant? And then David, your comment on this, and then we'll shut her down for today.
I mean, sure, and they do in a lot of cases. You know, CSC is a company, and cum laude group now, Mark Monitor, that they would do things like that for you, where they put their own information in for the registrant. So that does happen. there's discussions within ICANN to come up with some regulations governing um, proxy or privacy domain name providers, because that's essentially what the privacy is. So it'll be interesting because a lot of some of the registrars, I shouldn't say a lot, some of the registrars do not disclose the actual information, even when there's a UDRP. They'll disclose a privacy provider, but that at the end of the day hurts the registrant because that's a factor used a lot in bad faith. Um, I think there will be more discussions about the privacy aspects within ICANN, and they may um, there may be some policy that comes down on that, but sure, it already happens today that there's registered agents or corporate registrars that do this for you. So even if you file the UDRP, you'll get that registered agent or the corporate registrar.
Yeah, I'm just thinking like earlier you guys were saying like, somebody could file the UDRP, get the information, and then kind of almost cancel the lawsuit. So having a registered agent would almost kind of be the only way to stop that from happening, I think, because then it's like, you're just running into more paperwork and driving more costs. So it may not be effective to do that then.
You're right. And I think people are going to get creative and come up with ways to have a quote registered agent, basically without having to pay for registrant agent services. David, final words to you today. What's going on? David Michaels.
Which David? Michaels. Oh, fine. What's going on? I'm looking at how to use Claude to actually update WordPress websites and redesign them and upload my blog posts. Apparently, WordPress 7 has a Claude plugin, so that's big news. It's going to be able to transform website building.
Thanks everybody for being here. We're going to have a big show next week, so join us Tuesday, domain name law. And what we'll do is we'll try to get through the cases pretty quickly next week so we can have a question and answer session after for a little bit. We usually go 60 to 90 minutes. We tried to go 60 to 75 minutes. Today we're over. But all right, thanks everybody. And be sure to join Josh and I this Thursday if you're a domain investor. We do it at 10 a.m. Pacific, 1 p.m. Eastern. It's the DNX show. You can go to dnxshow.com to learn about that one. And you can, of course, our website for the domain name law show is dnlshow.com. Once again, thanks for being here. Take care of yourself. Enjoy the rest of your day or evening wherever you're at. See you next time.
Thank you.